Yeah. Well, I want to get to the abortion thing in a second, but this might also be a good way to sort of start the rest of our conversation with asking Mike, how important is the Supreme Court? How important? Well, there's two parts to that. How important is the Supreme Court, and how important constitutionally should the Supreme Court be? And it
Yeah.
sounds like the two are probably very different. So I don't
Right.
know what sort of word. I'm sure you could go on for hours, but in
Well,
a few minutes, tell
I
us the
think
truth.
I think a good way to kind of parse it out is to look at this the vaccine case that Carrie mentioned. From a libertarian frame of reference, yeah, that seems like a good ruling. But the truth of the matter is, we don't know whether it's a good ruling or not. And I think the problem that we have with the Supreme Court today is that we look at it as a policy-making body.
Mm-hmm.
And a court was never intended to be a policy-making body. So we can't really say whether or not her opinion on that vaccine case was good or bad unless we read the statute that Congress wrote and evaluate what that statute says, because the court's job is to evaluate the statute. Mm-hmm. And, she says that in her opinion that the statute did not support liability for these companies or taking away liability for these companies. But the majority of the court felt like the statute read differently. Well, I can't say one way or the other because I haven't read the statute. But this demonstrates the problem that we have today with the court. People view it as a policy-making body. She did this policy. She did that policy. That's not the Supreme Court's job. The Supreme Court's job is to look at a case and determine that case based on the law. And the law is, number one, the Constitution. Number two, the statute is written.
I'm sorry. Number one, the Lord. Just.
Well. Yeah.
Okay, sorry. Matthew.
I got to make things awkward. I'm sorry.
Yeah.
But yeah, so to answer your question more directly, the framers during the ratification debates, the argument was that the court would be the weakest of all three branches of the government. Alexander Hamilton wrote an entire essay in the Federalist talking about the fact that the court would be relatively powerless. It would be just deciding cases. And we now have a situation where the court has effectively become the lawmaking body in the United States, where it's dictating minute policy at the local level.
Why do you think that is, though?
Why do I think that is?
Yeah.
Because people like it that way.
Yeah.
People like it. They like being able to, there's this sense that if we can just control 5 judges, then we can basically have our policy imposed across the entire United States.
But is it how the Congress writes the laws that it allows for that type of interpretive power? Or is it just because as humans we have a little bit of an authority bias that we want to give power over to individuals or oligarchies? I mean, where does that where does that line up? I'm just trying to find that portion of it out.
Well, personally, I think it has to do with just the dynamics of how government has changed over the last. I mean, there's always been this jockeying for power among the Congress and the president and the courts, and then you can look at the states and local. I mean, there's always power. Anytime there's power, people with power want more power, and they want to fight over who gets to have the most power. And it just so happens that the nature of the court has allowed it to accumulate the most power. For one thing, you can't get rid of them; they're not accountable to anybody. And for another thing, in many cases, Congress, which is supposed to be the most powerful branch of the government, Congress has usurped its responsibility because it can pass things off and say, "Oh well, we can't do anything here because the court said." And they can shift responsibility, and they've shifted a lot of responsibility to the executive branch. So now we effectively have an elected king and an oligarchy of judges who effectively dictate policy for 320 million Americans. And I, quite frankly, think that's a really bad system of government. I think it's horrible. If you just look at the hue and cry that we have right now, we have this one vacant seat on the Supreme Court, whoever it may belong to, and everybody is like, I mean, there are people that literally, they've taken it to the hyperbole level of this is life or death. It's not a good system when an unelected, unaccountable lawyer who is really just a government employee has
Mhm.
this much power over
Right.
over any group of people.
Yep. Totally agree.
Yeah. Well, so thanks, Mike. I always appreciate your thoughts on like the outrage. Like you bring up the proper amount of outrage and analysis as to what's happening.
He's this Louis C.K. Black of or no,
No.
Louis C.K. No, Louis Black of libertarians.
Yes.
Yeah,
Yeah,
what
that
I
joke
am.
went down like an airplane. Jeez.
Yes.
Matthew, I'm personally offended by that.
Don't apologize, Matthew.
Your father-in-law should be
Yeah.
offended by that.
Was this some kind of never
thankfully
mind.
he's not. Yeah, I'll tell you off air, Mike. All right. So speaking of things that we should be offended by, Carrie, what is Ruth Bader Ginsburg record on abortion?
So this is the interesting thing, right? Because everybody thinks that Ruth Bader Ginsburg is somehow responsible for legal abortion. And she actually only was involved in 4 abortion cases, only one of which was a landmark case. 5 cases. The landmark case that she was involved in was Sternberg versus Carhart, otherwise known as Carhart 1. And basically what this case did was it struck down a Nevada statute that criminalized partial birth abortion. Now she was one of 2 Democratic appointees. The other 2 justices that ruled in favor along with her were Stevens, O'Connor, and Souter. But Carhart was actually overturned later with Gonzalez versus Carhart, it's known as Carhart 2. So her major contribution, like her landmark ruling, has been already overturned, and that Carhart 2 made partial birth abortion illegal again.
I'm going to show the deck on this.
Yeah, go ahead.
This is an absolutely amazing table, Carrie.
It really is.
Seriously.
Thank you.
Yeah.
So yeah, we have Gonzalez versus Carhart, and basically what that did. So the Partial Birth Abortion Ban Act, which was enacted in 2003 under George W. Bush, that was passed as a response to Carhart 1. And so, of course, they expected for there to be legal challenges. And the interesting thing about this case, and I think that we'll get into this more in the next segment, but I want to point this out. The reason why the Partial Birth Abortion Ban Act was upheld was not because we suddenly had pro-life justices on the Supreme Court, although you did have Thomas Scalia and Kennedy all ruling in favor of this. This was a Republican appointed majority who ruled on this. But the rationale for this was that Roe v. Wade and the other landmark case, Planned Parenthood versus Casey, which upheld Roe, both of which actually banned partial birth abortion. Partial birth abortion is not legal under Roe or Casey, and Carhart 1 was significant because that was a deviation from the precedent set with Roe v. Wade and Casey. So all Carhart 2 was doing was reaffirming Roe v. Wade and the fact that partial birth abortion should not be legal under it.
Yeah, that was one of those things that we had talked about before, and it really was kind of darned if you do, darned if you don't type of thing, where no decision on that is really good. And so you really, unfortunately, I mean, I'm looking at the record, and really you can't hang your hat of all abortion all the time solely on Ruth Bader Ginsburg. This is kind of mind-blowing, frankly.
Yeah.
I mean, let me just show this deck again, because Carrie, you created this, and honestly, it does a fantastic job at going through the cases by which abortion was an issue. And you look at this, and this is what, 24 cases?
24 cases.
3 of which were under Democrat-controlled benches. 1 was an equal outcome, and the rest are all Republican benches, which I would think a lot of people would find very fascinating to realize that a lot of the cases that decided the issue of abortion were done by
Republican
appointments.
I mean,
yeah. And that's the thing is, and actually, if you, I've got the cases sorted out according to landmark cases and what I call self-inflicted wounds, which I can explain in a minute. But basically, if you look at all of the cases from Roe v. Wade up to the Obama era, all of them were decided on by a Republican-appointed majority. We've had a quote unquote conservative court for, what is that, 3 decades? 3 decades.
Yeah.
And these are cases that are not just, they're not just affirming Roe. What they are doing is, I mean, you have, hang on, let me pull up my copy here really quick. Doe versus Bolton, which was decided at the same time as Roe. It was a companion case. Doe versus Bolton, what that did was basically said that it took the definition of the woman's health and broadened it to basically anything possible. Like if a woman's emotional health could be damaged by carrying the baby.
Yeah, expansive definition of health.
Right. She could have the abortion after viability. So this is what Roe v. Wade did. Okay. Roe v. Wade said that there was a right to abort that was protected by the Due Process Clause and the 14th Amendment. Now, what the court said about Roe is that the 14th Amendment doesn't give limitations on the right to abort, obviously, because it doesn't mention the right to abort. So the Supreme Court in Roe said that it was their responsibility to set those boundaries. And this is part of the major problem with Roe v. Wade, because we like to talk about the fact that Roe v. Wade acknowledges a woman's bodily autonomy. And so it talks about a woman's liberty interest and access to abortion and things like that. But her liberty interest is subject first to state interest. And so the state may be interested in protecting the potential life of the fetus, in which case they can restrict abortion. But the state may be interested in the health of the woman, in which case they can actually create mandates about how a woman can make choices during her pregnancy, which is to take away her bodily autonomy. And this is a quote from the case. They say, "We therefore conclude that the right to abort is not unqualified and must be considered against," get this, "important state interests in regulation." So this is the thing about Roe. Roe is not about a woman's bodily autonomy. That is secondary, because her bodily autonomy is subject first to state interest.
Literally secondary to state interest.
Yes,
Wow.
literally.
Yeah. Wow.
And they have an interest in regulating abortion. So this is a Republican. So the justices that decided this were Blackmun, Berger, Douglas, Brennan, Stewart, Marshall, and Powell. And of those guys, only Douglas and Marshall were Democrat appointees.
Wow.
Can I make some legal points?
Yes,
please
do.
that I think that will be germane going forward the conversation. The first point I think is really important for people to understand, and why the proclivities of a justice that's coming on the court today doesn't matter nearly as much as people think it does, is that precedent in the mind of a Supreme Court justice is almost at the level of the Constitution itself.
Yep.
you will almost never have a court reverse a landmark precedent.
Yeah.
I can't think of any landmark precedents that have been reversed off the top of my head. Obviously, I haven't read every Supreme Court case that there ever has been, but by and large, precedent is considered, and there are actually Supreme Court opinions where they elevate the jurisprudence of the court to the level of Constitution. So when people say, well, we're going to get this one judge in there and they're going to overturn Roe v. Wade, highly unlikely, because they're going to follow precedent.
Yeah.
And this is why I say, just in general, when people get so wrapped up in who the next Supreme Court justice, or I'm told that this is the most important election of my lifetime because this person will control who's on the Supreme Court.
Right.
A lot of these things, it's not going to change anything because the precedent has
Right.
been set and they're not going to overturn it. I think that's the first.
Mike, let me ask you about the thing that you brought up here. I don't mean to step on you, Carrie, but it pains me because the thing that we keep hearing about the courts and the appointments and the voting and all this stuff, and the thing that conservative or libertarian people who are pro-life would always hear was that we need these appointments so that we could have more pro-life policies, and that if any case comes up, we can go towards a pro-life agenda. But the record shows that that's not the case.
No.
And we're looking and that's the thing. But people say, well, the other side, is that what you're saying? Well, no, because I know given the chance, they would further it in any way possible. Yeah. But I'm just looking at this and saying, what do we do here?
So let me point something else out to you, because you're absolutely right about this, and Mike is also absolutely correct. And I want to talk about Casey for a minute, because Casey was another landmark case.
Well, can I make one more point and then I'll shut up.
He did address Mike for the question anyway, Carrie.
Oh, my bad. I'm sorry.
No, it's all right.
I think this is important too, because where this went off the rails was in the very first case.
Mm-hmm.
And I don't remember what that is, but this was even before Roe v. Wade, where they established this idea that somehow abortion was attached to this idea of due process. It's absolutely ludicrous. This whole idea of substantive due process is something that the court made out of thin air. There is no basis for it. It was just a way that they could empower themselves to make all of these decisions, not just on abortion, but on all kinds of things. Due process, it was very clear in the constitutional language, in both the original Constitution and the 14th Amendment, that due process, all that means is that before the government can do something to you, it has to take you through the process. Mm-hmm. It's basically it's a legal idea. It's the idea that they can't throw you in jail without allowing you to have a trial. That's what due process is. Due process has nothing to do with abortion. So they've taken this idea of substantive due process, and they've used it as a tool to basically allow the court to nudge its nose into everything in the world at the state and local level that it should have never had any business in. The federal government has no constitutional authority to be involved in abortion at all, period, end of story.
Yep.
This should have always been a state and local issue. I know people say, well, it still might have been awful. It's probably true. But I guarantee you, if it was decentralized, we would have at least some states with much more restriction on abortion than we have today.
Yeah.
Mm-hmm.
So that's basically my spiel on the courts and abortion. They shouldn't be involved in it. Now they are. So that leads to a lot of questions of how do we move forward. But
right.
I think it is important. If nothing else, I think people should understand the original Constitution, if for no other reason, to understand just how far this government is off the rails of what was intended.
Yep.
Well, disembodied head of Carrie, what do we do?
My disembodied.
That's justice, Carrie.
More like your elbow is disembodied.
It sure is. Okay, sorry. So I want to read some notes. So I came to this revelation about Roe and Casey when I was studying Walter Block's papers in preparation for my debate with him in New York. And I want to point out something that he talks about, because he summarizes the Casey case pretty well. And so this is what he says about Casey. He says the judge's concerns, or what the court was concerned with in Casey, because there was a question about overturning Roe with Casey. But the concern was that men and women had become accustomed to the existence of legal abortion and had organized their relationships according to access to abortion. And so their concern with overturning Roe was specifically that people had become accustomed to having access to abortion.
Good grief.
They also said that a woman's participation in society was dependent upon access to abortion. And they said overturning Roe would come at a great cost for people who have adopted thinking and lifestyles on the basis of access to abortion. So basically what they said in Casey was, even if we're wrong, people are used to it, and so we have to keep going with it. And then they also said overruling Roe, which was contrary to precedent, contrary to stare decisis, would weaken the court's authority to exercise judicial power and function as the Supreme Court of the land. They said that the court's authority depends on its reputation, and that would result in a great loss of confidence and unnecessarily damage the court's reputation. So this is very interesting, especially in light of Mike's comments about how the Supreme Court was supposed to be the weakest branch of government. Their ruling with Roe isn't just about abortion. It's about their own reputation and power to continue on with the power that they currently have. So it's about every other case as well.
I mean, that argument there is compelling, but I would say the argument about people's lives continuing in the way that it has been with Roe v. Wade is very true. Let's just hope a global pandemic doesn't upend everyone's lives and we have to shut everything down. So
that wouldn't happen.
No,
that wouldn't
has
happen.
never
Not at all.
happened.
let's
Not
go with
again.
that.
Yeah.
Yeah.
Well, I mean, the other thing is it's called the Supreme Court for a reason. So, I mean,
Because
it
there's
is
sour cream on
Right,
top.
because they're
Yeah.
supreme.
because there's sour
Oh.
cream on top. Nope,
Yeah.
that's not it.
That's just Taco Bell. Everything's supreme with sour cream.
I was thinking all
It's a regular taco, then they put sour cream in it. Now it's Taco Supreme.
You know,
What the heck?
comparing the Supreme Court to Taco Bell is a completely apropos analogy.
Yeah. Well, it in the end it has the same result. So
All just comes out.
So-
Oh my.
So, anyways, yeah, the
Mike
idea
didn't know what he was getting himself into.
didn't. So, yeah, you have these two landmark cases, which were, again, and Casey was decided by an all Republican court. Like, by the way, there was a Democrat appointee who was very consistently pro-life in his record, which was Byron White. But at any rate, now those are the two landmark cases. I had mentioned the self-inflicted wound cases, and that's my term. But you have a number of cases where, well, let me back up for a minute. When you think of conservative pro-lifers and their activism and what they're trying to do, you are thinking about things like, putting restrictions on access for like teens, or allowing canvassers to go protest at clinics, and trying to establish waiting periods and things like that, trying to put these smaller barriers in the way in order to discourage a woman from getting an abortion. And so this is the other problem with all of these cases is you have a series of smaller cases, which I have listed here. I don't think I can go through all of them, but a lot of them also ruled upon by Republican appointed justices, which include, like you had Bellotti versus Baird. They said that teens don't have to secure parental consent to obtain abortion. This was Rehnquist, Brennan, Blackmun, Stewart, Powell, and Berger. Those were all Republican appointees.
And it follows from the logic that they've built on this from the 1970s. The whole thing is built on, that's the way the legal system is built on blocks. You put one block on top of another. Yeah. And they're not going to knock out one of these bottom blocks. So it's going to keep going forever. Y'all want to know a dirty little secret?
Yeah.
Congress could solve this problem.
Oh, really?
Oh, yeah.
Congress has the authority to basically terminate jurisdiction on a given issue. So Congress could actually vote, pass a bill, and say abortion cases are no longer the purview of the court.
Wow.
And we'd be done with it. In fact, Ron Paul introduced such a bill on a number of occasions when he was congressman.
Wait.
Wow.
So if we just elect a majority of Republicans,
that's the answer. You found it, Doug.
Yes, I just
it.
figured out the solution to everything.
That would be the
most
second
important election.
It would be the second thing that they did after they got rid of Obamacare.
Yeah, right. Exactly. Well, there's one more case that I want to point out.
Clearly, you don't watch TV, like,
right?
You know.
There's one more case I want to point out, which was Webster versus Reproductive Health Services, where the United States Solicitor General actually advised the court to overrule Roe with this one, and they did not.
Oh my word!
Rehnquist, Kennedy, O'Connor, and Scalia. So Scalia was supposed to be the major pro-life. Yeah.
Seriously.
You have to understand what Roe was about. Roe was about controlling women's bodily autonomy because it was secondary to state interest and regulating abortion.
Wow. The state owns you.
However bad those are, I do have to say the worst of them all is City of Akron versus Akron Center for Reproductive Health. I mean, who's with me? Let's just end Akron. Hashtag
Akron.
Well, like we're nuking the whole city? Is that
what we're just done.
No, we don't need
We're just done with them.
We'll just ignore it.
Goodbye, Akron, Ohio.
Where are you going to get your tires?
We'll do it the way the UN ignores like Singapore. We're not Singapore, but Taiwan.
Taiwan. Yeah. Right.
Yeah. So, okay. I want to play devil's advocate here and give, so we have this list, pull this list up, right? So you have them labeled red and blue because they are Republican appointed and Democrat appointed, right?
It's more like a pink and sky blue.
This is a proxy for, and this does definitively sort of disprove we need a Republican in office to nominate Republican appointed judge. That it does do that. However, in the interest of understanding the nuance of the nominating process. You can leave it up however long you want, but in the interest of thinking about the nominating process, right? A president is going to nominate somebody that is going to appeal at least to some of the dissenters of the opposition party, right? And so the argument could be made that we just need a strong president who's just not going to take any BS from the other side. He's just gonna do what
Douglas.
Right.
Right.
No, Rise of the strong man.
It's a little bit of so the table doesn't tell the whole picture. It tells the picture of who was appointed by, or were they appointed by whom, but it doesn't mean that those people were right or left, right?
Yeah.
Or right or left, or however it works here. But it does give us, can't tell us everything. And so couldn't it be said that some of these people are actually pretty decent judges, even though they were actually, appointed by Democrats?
Well, yeah, possibly. I mean, I've already pointed out that Byron White had the most pro-life voting record, when
he was appointed by
the Democrats.
Okay.
So yeah, in fact, somebody had even pointed out to me on Twitter that there were a number of the court justices on the ruling of Roe who had been appointed by Republicans. They were just simply liberal in their ideas. They had they weren't genuine conservatives, and that's true. I mean, there's no reason to believe that some of these justices weren't genuine conservatives. Mm-hmm. But that's sort of the point, right? Is Republicans will nominate who they think they can get on the bench, given the current political climate. So even Trump, Trump could, let's just assume for the sake of argument that Trump is the most pro-life Republican president we've ever had. I know, snicker.
I wouldn't doubt it.
He would still have to name an appointee that would get through the process.
Yeah. It's interesting too, because
John F. Kennedy, by the way, Byron White was appointed by John F. Kennedy.
Yeah. Well, there you go.
If you're looking at things from a libertarian lens, libertarian ideas don't necessarily line up with Republicans or Democrats. So you end up with the situation as a libertarian. I look at some of these folks, and I look at a Ruth Bader Ginsburg. There were some things she was very good on. She was very good on the Fourth Amendment. Yeah. Kavanaugh, who Trump nominated, he's horrible on the Fourth Amendment. Yeah. Look at Ruth Bader Ginsburg, the things that she did in terms of contract that Carrie mentioned at the beginning. That's probably one of the few cases ever that, actually properly applies the 14th Amendment and what the privileges and immunities in the 14th Amendment were meant to protect. Contract was among those. So she was very good on that. She's not good on abortion. So, it's from a libertarian standpoint, it's very difficult to look at any of these folks and say, oh, they're great or oh, they're horrible, because they're all a mixed bag, because, Democrats nor Republicans really line up with libertarianism